18 exclusively for you. We're putting out the details of that judgment where it's a split verdict that has been given by a two-judge bench. What is it that Justice Dhulia and the other judges on the bench are really putting out? All the details we'll put here on CNN News 18. Going through that order, which is roughly an order running in about 200 pages, both the judges expressed their opinion about why they believe. One judge believed that the Karnataka High Court judgment was correct. The other thought that this is a departure from the established precedents. And in fact, the Jehovah Witness case, or what you call the earlier case which has been referred for individual liberty, is Bijoy Emmanuel case. That is the correct legal position. Let me try and cut across to my colleague Ananya Bhatnagar, who will get us more details on this entire judgment. But to begin with, the judgment begins by talking about the history of secularism under Indian Constitution. How secularism was introduced, what is the meaning of Dharma Nirpeksh, that's the word, or Panth Nirpeksh, that's the word that the judgment really talks about, and what has been the evolution and characteristics of secularism in India. The judge also goes ahead and analyzes and talks about the fact that India has a very, very special character, and I'm talking about Justice Hemant Gupta, who upheld the Supreme Court order. I want to cut across to Akanksha, who's with us on the broadcast. Akanksha, let's go to the first 3 to 4 pages of the judgment. And as I scroll through page number 6, page number 7, it's interesting how the Supreme Court is analyzing, Justice Hemant Gupta is analyzing the characteristics of secularism under Indian Constitution, because that's the entire debate here. What is the meaning of secularism and what are the limitations of the state institutions?
You've raised a very valid point. The whole prognosis is about secularism. In fact, earlier in the verdict also they alluded to the international jurisprudence which adheres to what is the norm of secularism, how is secularism defined in various other countries. France was talked about, South Africa was also talked about, and then they spoke about positive secularism versus negative secularism. And since CNN News 18 has now accessed the detailed copy of that order, it's important to talk about the questions that are mentioned in this order, which are mentioned categorically on page number 21 and page number 22 and so on and so forth. I'm going to also take our viewers through what these very critical and significant questions are all about. Remember, basis on all of these questions now, the entire case has been now moved to the CJI, who will now be constituting a fresh bench, as we've already informed our viewers. So question number 1 is, what is the one of the important questions is that what is the ambit and scope of the right to freedom of conscience and religion under Article 25? What is the ambit and scope of essential religious practices under Article 25 of the Constitution? Remember, Article 25 has been referred to. They are talking about what is going to be defined as essential religious practices, because even the Muslim Personal Law Board has been raising this question that hijab is an essential religious practice, something that the AIMIM chief Asaduddin Owaisi also talked about. So what is the scope and the ambit of essential religious practices? Does hijab come under that? That is one question which is being raised in this order. Whether fundamental rights of freedom of expression under Article 19A and right of privacy under Article 21 mutually exclusive, or are they complementary to each other? Whether the government order does not meet the injunction of reasonable for the purposes of Article 21 and Article 14. Basically, the crux of the matter is, it is questioning how reasonable is it to in fact impose the ban on hijab. Does it come in the ambit of religious practices? Should this now also be included as the right to religious freedom? Okay. These are all very critical questions that have been posed in this entire order.
So let me break down the parts that Akanksha is referring to. So these are two separate judgment, viewers. We'll have to divide them. One is Justice Hemant Gupta. Justice Hemant Gupta essentially in this judgment has said that what the Karnataka High Court did was correct. And I'm not going to change that order of the Karnataka High Court. There are 11 questions that the court framed. Now, if I were to distill down those questions for you and simplify it, first is whether the matter should be referred to a larger bench. Now, with the split verdict, inevitably the matter goes to a larger bench. But more importantly here, you'd remember the Sabrimala case. In the Sabrimala case, there were wider questions that were left open. Wider questions that Akanksha was talking about. What is the limitation of Article 25? How does Article 25, which is my right to religion, actually interacts with Article 19, which is my freedom of expression? And how does it really interact with the reasonable restriction, which is the right of any state? So that's one very important point which is still pending, a wider question which is pending, and Justice Hemant Gupta believes that this matter should be tagged along with the Sabrimala case. As and when that will be heard, it will be heard by a 9-judge bench. The second point, and Ananya is also with us on the broadcast. Ananya, come in on this point as well. Can the right to wear hijab be claimed as freedom of expression? Is this covered under Article 19? One of the arguments that the petitioners had raised was, we are covered by the Puttaswamy judgment. This is our freedom of expression. Allow us to do that. And that's one of the key questions that has been framed. Talking about the order or the judgment rendered by Justice Hemant Gupta, take us through the key portions of the rationale which has come out. Ananya.
Well, definitely, the proportion here remains to be seen in that though Justice Hemant Gupta has actually dismissed these appeals, while Justice Dhulia has actually gone into, in fact, allowing these appeals. A beautiful judgment has been written out, in fact, by Justice Sudhanshu Dhulia, and I'd like to take you through these pointers.
Okay.
So, these pointers actually, the very important point that is there is, under the constitutional scheme, wearing of hijab should simply be a matter of choice. It may or may not be a matter of essential religious practice, but it still is a matter of conscious belief and expression. If she wants to wear a hijab, even inside her class, she cannot be stopped. If it is worn as a matter of her choice, as it may be the only way a conservative family still will permit her to go to school. And in those cases, her hijab is the ticket to education. The unfortunate fallout of hijab restrictions would be that, in fact, the girls would miss out on their education. So beautifully, how Justice Dhulia has actually taken up a problem that had persisted, in fact, in India, and specifically in the Muslim side, where girls are not allowed to wear the hijab when girls are asked to wear a hijab whenever they go outside, and if they don't do so, they are not allowed to go out. So this has been addressed by Justice Dhulia, and that is why this opinion, this in fact judgment has come in from his end, allowing these appeals to waive off the hijab ban. And now, very interestingly, the matter now goes before a larger bench, which would be either a 3 or 5 judges bench that the matter would go to. And it would be very, very crucial, Anusha, to see as to who would be these judges and whether the matter would come up before Justice Lalit's retirement or post that. Anusha.
I'm going to go to the part that Ananya was referring to. Justice Dhulia has written a very interesting judgment, as Ananya rightly pointed out. If viewers, you go to page number 71, and these judgments are available to you on the Supreme Court website. Any citizen of the country can download this judgment and read it. Justice Dhulia goes on to say, paragraph 81, that the unfortunate fallout of the hijab restriction would be that we would have denied education to a girl child for whom it is still not easy to reach her school gate. This case here, therefore, also has to be seen in the perspective of the challenges already faced by a girl child reaching her school. The question court would put before itself is also whether we are making the life of a girl child any better by denying her education because she is a hijabi. That's the word. Those are the words that the judge is using. Paragraph